You're watching the award-winning GHS-TV, a nationally recognized student television station.
Welcome to Let's Talk Business. My name is Kelly Bolton, and thank you for tuning in as we have the distinct pleasure of hosting our community's foremost leaders, entrepreneurs, and civic heroes. In life, two things are certain: death and taxes. In addition to paying taxes throughout our lifetime, we may even have to pay taxes upon our death. We would all much rather pass our wealth on to our loved ones rather than the government. Today, we're going to discuss the many ways available to help you in this area. And joining us for this discussion, we're thrilled to have with us Ms. Beth Bradley. She is with Birch Porter Law Firm. Beth, thank you so much for joining us.
Glad to be with you today, Kelly.
Well, I know this is not a topic that people like to discuss. They don't want to talk about death, and nobody wants to talk about taxes. But as I said, those are things that happen. And so given that we know that at some point in our life we are going to die, I know that certain documents have to be put in place to help us pass those assets on to the people that we love. So that is a will, correct?
It is. A will is just simply a legal document that allows you to direct how you want your assets to pass after death. So most people consult with a lawyer to do a will. And to your point on taxes and making sure that your assets go to your loved ones or your intended beneficiaries, a lot of people are surprised to learn that there is a tax that you get taxed for many different reasons, but among them you get taxed for the privilege of having leftovers when you die. In other words, if you don't spend all of your assets during your lifetime, you could potentially owe taxes to the government. So my clients are often surprised to learn that you are taxed by two different entities. One is the state in which you are living at the time you die, and each state can make its own rules about what type of taxes will be imposed on those leftovers. Generally, you get a free pass if you choose to leave your assets to a spouse or a charity. But if, for instance, you are the second spouse to die and you want to leave your assets to your children, you may be subject to some death-related taxes.
And not many people get excited about that. I mean, we all love the freedoms that our country gives us.
Yes.
And we all love the ability to vote and live in this democracy, but most people have their own opinions on how tax revenue is spent.
That's
so I think I've been practicing for 32 years in financial planning and money management, and I have yet to have anyone send the government an extra check because they want them to be the beneficiary of some extra money. So
absolutely.
Have you?
No, I too have been doing this for over 30 years and have the same experience. So I am proud to say that in our state, the state of Tennessee has repealed its inheritance tax, which is good news.
That is fabulous news.
Other states may have different rules, but Tennessee, there is no inheritance tax. I mentioned before there are two taxing entities. So the other entity is the one I think you're referencing, which is the U.S. government, the federal government.
Yes.
But there's good news about that as well. Throughout our lifetimes, we have been given what's called an exemption, or an amount a coupon in essence, that you can use to pass assets to your loved ones other than a spouse or a charity. The amount of that coupon, however, has varied greatly over the past years. Currently, it's very high. It's over $11 million.
That's a lot of money to be able to pass.
That you can give away.
And it's my understanding, Beth, that's per person. So if you're married, I get over $11 million and my spouse gets over $11 million.
Absolutely.
Before any taxes are paid.
Before any death-related taxes are paid or
and
owed.
I guess what you said is important, death-related taxes.
Right.
Sometimes some of the things you inherit may require income tax.
That's right. So that does give a lot of freedom to carry out your intentions as to who you want to benefit. And as you mentioned earlier, more often than not, that's accomplished through the use of a will.
And so let's talk for a minute and maybe back up. You said you've been doing estate planning and it sounds like almost exclusively estate planning and kind of family wealth planning for 30-something years. So
That's right.
I'm sure you've seen a lot of changes.
I have.
But I would bet the one thing that hasn't changed is the will. The will is a document that has stayed the same. Now, how you use it has been different, but a will's been around for years and years and years in the use of a will.
Centuries, correct, right.
So can maybe you explain what is a will and how do you use it?
Right. Well, a will, just in essence, is a legal document that solidifies or puts in writing as a formal legal document about how you want your assets to pass after you die. A lot of times clients are interested to know, I think they've watched a lot of movies.
Right.
You know, will there be a reading of the will? Does every will have to go to probate? So those are often questions that clients are interested in. You know?
Well, I was going to ask you that. So if you have a will has to go through probate. And probate is the process of taking the will before a judge
Right.
and saying, these are the terms of my will, and I am the executor, the executrix, the person that is to carry out the will.
Correct.
And that process is what they call probate, correct?
It is.
Okay. And does every will have to go through probate?
No, not every will does, and I would say, in fact, for many years when the exemption we talked about earlier was lower, planning to avoid death-related taxes was a primary objective. Today I'm finding that more people are interested in how easily and simply they can transfer their leftovers to their loved ones. So a lot of planning now involves, do we need to go through probate to get the assets down to the intended beneficiaries? I would say that a will in general governs assets that an individual leaves behind that don't otherwise contain like a beneficiary designation or a transfer on death designation. In other words, you wouldn't know who would get the asset unless you looked at this legal document, the last will and testament, to know who gets it.
That makes sense. And you know, Beth, something I wanted to stop for a minute and talk about, and I know we've worked together for years, is that I have seen people have a will and they say, this is who I want all my money to go to.
Right.
And then they have a life insurance policy with named beneficiaries, and they have a retirement account with named beneficiaries, and they're not the same as their will.
Correct.
And then things change and they say, Mr. Attorney, I want to change my will. I want these people to get my money. And they change it. And they don't change the beneficiary designations, and they think the will wins out. So which one do you look at? If I have a beneficiary designation and you have a will, which one wins out?
Well, what you're talking about when you reference a life insurance policy or a retirement plan is what we call a contractual asset. So those assets are a matter of contract. That means that they're governed by the beneficiary designation. So the beneficiary designation wins out.
Which can be problematic.
It can. So Kelly, I could hand you over a will that says I leave all my assets to Kelly Bolton, but if on my life insurance policy I have designated my husband instead as the beneficiary, you lose out on those. The insurance company is going to pay those to my husband because he is listed as the beneficiary.
And I've seen that happen. Well, thank you. We're going to pause for a short commercial break, so please stick around and we'll continue this discussion with Miss Beth Bradley. That's always the weirdest part.
And it's very fun to be in band, trust me. It's so much fun.
When I was an 8th grader and I saw them march and I was like, wow, I need to be a part of this.
Our main performing group is the varsity band. That encompasses our marching band and our varsity concert band. We also have the jazz ensemble.
It's unique, so we're really lucky to have that.
I'm very methodical about teaching. I try to stay up to date because I want my students to have the best information that I can pass along to them.
He's excellent. He commands a sort of drive that we didn't exactly have.
I lead the class, but I also believe in the students self-assessing their work.
The leadership is led by the students. We lead most of the practices. It's basically just student-led.
And I think it's important for them to take that kind of ownership.
If you want to be a musician, you gain extremely important music skills, music techniques.
1, 2, 3.
There's so many opportunities for fellowship, and band is a family. And you develop that small community where you support each other, not only musically, but in many ways.
Really, without the band, the football games would be lame. Without the band, you wouldn't really have the pep rallies. The band is like a good foundation for the school spirit. If you want to join band, just do it.
I think band was the best part of my high school career.
For more information about the Kappa program, visit ghskappa.com or call 755-7775. You're watching the award-winning GHS-TV, a nationally recognized student television station.
Welcome back to Let's Talk Business. If you're just tuning in, I am Kelly Bolton, and today we've been discussing the importance of estate planning. To continue this discussion, we have estate planning attorney Beth Bradley with us. Beth, before we took a break, we were talking about this unfortunate thing that I've seen over and over again, where people have a will, but they have beneficiary designations and they don't match, and they think the will is going to override the beneficiary designations. And I was just wondering, when someone comes to you and does an estate plan, and you draft their will as the document of the asset passing, that's not enough. They need to do, can you maybe explain to our viewers what they need to do when they have a will done, how they need to make sure everything's going to work?
Sure. When I meet with my estate planning clients, we usually first identify what their objectives are, and typically that involves identifying who their intended beneficiaries are and whether there are any unique circumstances. Things of that nature might be that you might have a beneficiary who is immature or who needs a little help with their inheritance, with managing their inheritance. But if you are one of the lucky individuals who has the perfect family with mature adult children, there are some ways that you can simplify getting the assets down to the children, which is typically, in a typical family with a married couple and adult children, that typically their objective would be to provide for the spouse for life, and then to pass the assets down as quickly and simply as they can to the adult children. So what we do is we review the assets that they own to determine the manner in which they're titled. For instance, most married couples, if they own a home, that home will be titled in a form that we call tenants by the entirety. That's a special form of ownership for married individuals, which means that on the death of the first of them, the house will automatically be vested in the name of the survivor without any need to go to court or do anything of that nature.
So no probate?
No probate needed in that circumstance. Now, a lot of times when I meet with them, they will be interested to know, well, what happens on the death of the second of us, to the house. So a lot of times clients are surprised to learn that there are different forms of probate. You hear about probate and think of it as a kind of one-size-fits-all or a single type administration. But actually, there are different forms of probate that a client can use depending on what assets need to be transferred after death.
Okay, so what are those types of probate?
Well, one type, for instance, if the only asset that needs to be transferred on the death of the second spouse is a house, Tennessee recognizes a streamlined or simplified form of probate that's called a muniment of title. It's kind of an open and shut deal. It's a little bit akin to recording a deed, which just serves to show that the title on the death of the second spouse would pass to the individuals named in the will. So the will is admitted to probate, but in a simplified version called a muniment of title.
Well, it seems to me, I'm trying to think of, Beth, like an example where somebody wouldn't want their spouse's name on it, and I'm thinking it might be somebody that's in a litigious business.
Right.
Sometimes people want to keep assets out of their name for that reason.
That's right.
And I guess, because a lot of times, obviously, the easiest is if it makes sense and you want the
Sure.
person to get it, to have it in joint names because it just easily passes. But that's good to know. So if they just want to keep something out for that purpose, what about if there's just cash accounts?
Right. Cash accounts too, if that's the only asset left to be transferred on the death of an individual, you might have some choices. Tennessee is the state that recognizes what's called a small estates affidavit. So it's an alternative to a full-blown probate administration. And the difference there is that the individual, typically the one who was named in the will to be the executor or the personal representative, will fill out some forms at the probate court. You don't even need a lawyer to do this. If the assets at issue are cash accounts or accounts that are valued at less than $50,000, then this kind of streamlined process can be used as an alternative to the full probate administration.
Well, that's nice. Now, is probate expensive?
It depends. I would say that from what I've learned from other states, some states it can be very costly. You know, most notably I think Florida and California are some that come to mind, but Tennessee is fairly straightforward. And how costly it is depends on what type of probate is needed and also how involved it is. I mean, we've all, you know, we're familiar with Bleak House.
Yes.
We know that there can be will contest and disagreements among beneficiaries.
Oh, yes.
A lot of that is out of your control, and you can't really know that on the front end. But I would advise individuals who need to go through probate to consult with an attorney who's willing to handle the probate just based on the number of hours
And
it
they
takes.
could, so
Right.
you can either have probate fees charged based on, depending on how the attorney does it or whatever agreement, it could be a percentage of assets or the hours it takes for them to process the probate.
Well, I would say ethically, the percentage of assets is no longer really an option. Our courts have found that that is not really an appropriate way to charge beneficiaries on estate matters, and that more appropriate is an hourly rate based on a lot of different factors, including, how complex the assets are, if there's litigation involved, things of that nature.
And that makes sense. That does. We're going to pause for another short break, so please stick around as we continue our discussion on how to protect your family and your wealth.
GHS-TV started in 1982, and it was just a couple of cameras, a couple of on-air personality, and it's really grown into what you see today. It's a multi-million-dollar studio with top-of-the-line technology.
Being able to operate, all of the machinery in the control room, being able to use all of our software and hardware that we have around the studio is a great skill because this is top-of-the-line equipment.
I feel like this class has brightened my horizon. It's something that I never thought I would be doing, especially as a student.
GHS-TV is probably one of the most hands-on experiences a student will ever get in their lifetime.
Welcome back to Crosstalk. Nothing really has just the vibe that we have here.
Especially after you finished, you get a real rush of, wow, I just did that.
By the time a student graduates from Germantown High School, they will know pretty much every position there is, from producing to directing to on-air work.
You learn time management, you learn organization, you learn how to work with people, how to better communicate with people.
We put a lot on them, and they have to be able to have the responsibility and the knowledge to get everything that we ask them.
I had very little experience, so in the past 3 years, the skills that I've learned have absolutely exponentially grown.
The class has actually helped me figure out that I want to go to college for journalism.
When a student graduates, they are the best possible version of themselves that they can be.
Thanks for tuning in. We'll see you tomorrow.
For more information about the Kappa program, visit GHS-Kappa.com or call 755-7775. You're watching the award-winning GHS-TV, a nationally recognized student television station.
Thank you for joining us on Let's Talk Business. I'm your host, Kelly Bolton, and today we've been discussing the tremendous impact that estate planning, taxes, and wealth planning can have on us even at death. Joining us on this very important subject is Beth Bradley, an attorney with Birch Porter Law Firm. Beth, thank you so much for sticking around, and we've got the final segment of our show, and I feel like we need a lot more time. So I was thinking during the break of some things I want to make sure I get you to answer.
Sure.
And one of the things was, what if there's no will? I mean, what if there's nothing?
Right. Well, the will does give the individual an opportunity to express his or her interest and who they want their intended beneficiaries to be. If they don't elect that option, a lot of time what will happen is the law steps in to determine who gets the assets they've left after death.
And I think let's repeat that one more time.
That's right.
If you don't make a plan for yourself, the government or law will give you a plan.
Right.
It just may not be the one you want.
Exactly.
So although none of us want to talk about death and dying and taxes, none of us do.
Right.
We got to remember, if we don't come up with a plan, the government's going to give us a plan.
That's right.
So it's probably better to do it on the front end.
I would agree with that, and I will tell you that I think there's a common misperception among married couples that if you don't do a will, then the spouse will just get everything anyway, so what's the big urgency?
Right.
But I can't speak for every state, but I know the rule in Tennessee is if you die with assets that you own individually and you have both a spouse and children, your inheritance is split among the spouse and the children.
Even if your children aren't children you trust with money.
That's right.
Even if your children have problems financially.
Or if they're minors, which is really problematic because, as you know, you have to be 18 to be capable of inheriting money or managing it outright. You have to legally be an adult. So if you don't take the time to do a will or to do some planning in this regard, and you have children who are minors that might potentially inherit, that can really present some problems.
That can be a big problem.
Right.
And you know, another thing, and we don't really have to get in the weeds on this, but if you get into second marriages
right.
with blended families, it's my understanding, unless they've changed the rule, that based on the amount of time that you've been married, unless you've done some type of prenup, postnup,
right.
your spouse has to get a certain percentage of assets.
That's right.
And I know I've been involved where there's arguments from one side or another, and unfortunately at death a lot of times it brings out the worst of us. Emotions are flying high, and you've got a lot of tension, and things get said you don't necessarily mean, or maybe you mean it, you just wish you hadn't said it.
That's right. Said them that way.
But I've seen situations where there was not proper planning and assets did not go according to plan. So those are things to definitely, I know, think about and consider. You know, just a sidebar example, several years back, somebody that was referred to me was the lucky beneficiary of an ex-husband's retirement plan.
Oh dear.
And she was thrilled.
Yeah, it sounds like maybe there wasn't some follow-up
there was
in
no
connection
follow-up
with the divorce.
She was very happy about her inheritance from her ex-husband, and I've seen many situations similar where, you know, an angry family member decides to cut a child out or and give it to somebody else because they're being nice to them at the time.
Right.
But it was just a bad moment in time, and things don't go as planned. So sounds like getting the will done, but doing it in a thoughtful manner, expressing to the attorney what your desire is, if you're married, what your spouse's desire is, so that you can then figure out the way legally to make that happen so you don't leave it to chance.
That's right. I mean, I consider my job to be a facilitator to help the client achieve their objectives, you know, in the most expeditious manner.
Well, and talk about expeditious. Is probate fast?
Well,
I don't hear many people talk about how it was so quick and easy.
Well, it can be quick and easy.
Okay.
And I would say, back to what we discussed before the break, there are different types of probate. And you'll recall I mentioned the one that applies to transferring real estate. Muniment of title is a one-day deal. It's an open and shut, you know, basically recording of the will to operate almost as a deed. The small estates affidavit too is one that isn't hemmed in by a certain time frame. A traditional probate, again, this varies from state to state, but Tennessee's is not very burdensome. We have a period of 4 months for creditors to file claims. You know, probate itself is kind of a final reckoning. It's a process where you pay all the decedent's legal debts and give the creditors an opportunity to speak up and say what they're owed. Once those are addressed, then the remaining assets pass to the beneficiaries designated in the will. So there's a set period of time to identify the creditors and the debts and see that those are paid. I think that period is different in different states, but it's relatively short in Tennessee. It's 4 months.
And I think, well, from what I've seen, it sometimes gets drug out because of parties involved.
Certainly.
Either the financial institutions are not cooperating, beneficiaries aren't emotionally ready to handle it, an attorney is busy, whatever it is. But if everybody's on their A game, it does seem to me to be a process that can go a little quicker. Now, there are alternatives to wills, and I know we have a very short period of time. I'm just going to mention there's trust. That can be a great alternative. Absolutely. But kind of my final question to you is, how often should someone review their legal documents?
Well, I would say anytime there's a major life change would be a trigger to review your estate planning documents. You know, if you have a death of a spouse or anyone who's been named as a fiduciary in your documents, if you receive an inheritance, if a child becomes an adult and might be able to assume some of those fiduciary roles, all of those are triggering events.
And I'm assuming even changes in tax laws.
Absolutely. Sometimes those can be hard to keep track of.
You know, and I like to think of it this way, Beth, kind of on my final comment is, you know, we go every year for our physical.
Yes.
It seems to me that we don't spend enough time taking a physical, you know, if you will, account of our finances, whether it's financial, the money that they manage, their estate plan, or meeting with their CPA to make sure they're minimizing taxes. We spend all day working so hard, and we make sure that we're going to the doctor so we can stay alive, but it seems a lot of times I find that people don't make the best use of their financial resources. But I think people fear it's going to cost me money if I call Beth. If I call her, she's going to charge me. And I know you are fabulous about reviewing things, you know, to see if you can assist without sending somebody a big bill. If you can assist, then you jump in and you give an estimate for costs. So I wish we had more time. But once again, I'd like to thank Beth Bradley for being with us today. Like the saying goes, there are two things certain in life, death and taxes. Hopefully, this show and our work with Beth Bradley will at least help you avoid some taxes at death. So for more information on our show, please check us out on the web at GHS-TV.org, where we're streaming live 24 hours a day. You can also check us out on Facebook and Twitter. I hope you've enjoyed our discussion, and I hope you will join us again next month on Let's Talk Business.